From item number 1 to 6.
Wait, please, Your Lordship, my lord. I beg to mention item number 6, my lord. I pray for an adjournment. I'm filing my objection, my lord, in the IA.
Let it be called out. Let the case be called out.
My lord.
Item number 7 to 15. Item number 16 to 27. Adjournment request.
Maybe you lost. I beg to mention item number 16, my lord.
16.
16, my lord.
Yes.
And then due to some personal difficulties, I'm paying for accommodation for the day in this. I've informed.
You are for,
a respondent, my lord.
have you informed the other
Yes,
side?
and I've informed everything. They're consented.
Tomorrow it will not be possible. We'll give you next week.
Yes.
As break for on behalf of the respondent and agreed to by the council for the appellant. Let this matter come up for consideration next month.
Give the way.
8-6. Any other request?
Wait, please, Your Lordship. Lordship, I basically pray before listing this IA Lordship. By tomorrow or day after tomorrow.
What is the matter about?
Lordship, the respondent in this case going to appoint the selected incumbent vice supervisor in the seniority list Lordship.
Day after tomorrow.
Deeply obliged Lordship.
Follow.
Daily list for this item 1.
The lodging order is 2640.
Follow. It appears that all the respondents have been served. In that way, the matter list this appeal for admission on what date? Sometimes in July. July.
28 July. Item 2.
Person needed legs, so may I pray that I may be allowed to submit my on behalf of them.
What is it?
The petitioner in person needed legs in the different court, my lord.
No, that's all right. Not for the merits of the case. Now, has respondent number 6 been served?
Yes, yes, my lord. It was included by the order dated 28/10, my lord. 2024, my lord. Respondent number 6 was.
Who appears for respondent number 6? Which government advocate? Government respondent. Government. Director Official Language Implementation Assam. Sharma? Then you have to find out, we are placing it for admission, not. Again, all the even the newly, all the respondents have been served. Let this matter come under consideration. Under the appropriate heading.
24 July. Item 3.
In terms of the office note dated 29/5.
The respondent number 1 has been served, but there is no appearance on his behalf today. Stop awaiting. Giving one more opportunity to respond number 1 to contest this appeal. The matter is adjourned to. Like.
28 July.
Court forgiven.
Item 4.
Why have you not taken steps?
I know.
You have not taken
The-
steps for each.
The petitioner is expired on 20th April. So I have submitted affidavit to close the case.
In view, in the counsel for the petitioner submits that with the death of the petitioner, there would be no necessity of pressing this application any further. The writ petition is disposed of as has become in fact.
Item 5.
Awaiting the service of notice on response number 14, 21, 32, 43, and 50. The matter is 50 and 52, the matter is adjourned.
Understanding court order 17-9, my lord. Some of the respondent died, my lord.
You have to file that application.
My lord,
Lordship, actually, what happened, we filed an affidavit, copies of them then, unfortunately, it's not an.
All right, we'll see. But let these persons who are alive, they may be served
my lord.
and rest we'll see.
My lord. We'll take fresh steps, Your Lordship.
Not at all. We are awaiting the appearance.
27-7. Item number 6.
She is for respondent number 1.
My lord, I beg,
Yes, you want to respond to the application
my lord,
as per it for the land council for the respondent seek some time to respond to the petition seeking condonation of delay of 221 days in conformity to it. So let such an affidavit be filed positively by the next date, re-notify under the same heading on the date in July.
22nd July.
oh, blah.
Item 7.
May it please, Your Lordship.
Yes.
Yes.
17 days within honor review.
Yes.
Yes, Your Lordship, I'm appearing as a petitioner in person in this matter, Your Lordship.
Yes.
Actually, on 19/11/2025, the
Yes.
PIL, that is PIL number 18 of 2018 was dismissed due to non-prosecution of my side, Your Lordship. And eventually I have filed in miss case, that is miss case 02 of 2026, where 17 days delay was there. Therefore, along with her, IA has been filed, Your Lordship. And on 02/04/2026, the Honorable Court has recalling recalling an order which was passed on 13/2/2026.
Just a minute, give us a minute.
Yes, Your Lordship.
It's restored to. Now, so Union of India will accept, who appears for Union of India here, accept notice. I accept notice, we condone the delay of 17 days. Let the PIL be heard. The delay is got the notice to Union of India and others accepted by so and so. The delay is condoned, the appeal is allowed. The appeal be processed, the petition be processed and be listed on so. All right.
Oblige, Lordship.
4th August. 4/8. Item 8.
Where is the order?
Relevant part page 21.
No order has been passed.
No.
Okay. The directions contained in the judgment dated 26/11/2025 passed by this court in WPC number 994 of 2020 has not yet been complied with. So let notice be issued to, who would be the answering respondent?
1 and 2.
Let notice be issued to response number 1 and 2.
Yes, sir.
Response number 1 and 2. For let notice be issued to respond number 1 and 2 to explain as to why contempt proceeding be not initiated against them for non-implementation of the direction referred to one. The notice to respond number one is accepted by Mr. Mora.
No, Mr. Where is it?
Ask Mr. Khatniar to accept notice. Both one and two. Mr. Khatniar, ask him, where is he? I'm talking to the state councils. You have to respond, no? If your colleague is not here, you have to respond.
So sorry.
Inform. Just don't keep burying your head down.
No,
That's not.
I didn't understand because
That's not going to save the. Let's
No,
not
no.
behave like ostrich. Allow the wind to pass off. No, that's not done.
Nothing like.
Now, if there is no.
I will inform Qatar.
Yes. So we say that Mr. Khatniar accepts notice.
Yeah.
The notice is accepted by Mr. Khatniar, learned so-and-so, for which department you be in, who shall respond to this petition by the next date. Let extra copies be furnished let extra copies of the petition be furnished to Mr. Khatniar during the course of the day. July.
29 July.
Inform Mr. Khatniar.
Yes.
Item 9.
44 days. Represented by standing counsel PNRD and document.
Mr. 44 days delay.
Yes, who accepts notice?
One,
Except for 3 and 5.
two,
And for 1, 2?
1, 2, 4.
Conspire
As doctor
as doctor.
for stationing.
1, 1, 2.
1, 2, 4.
Yes.
Ask him to accept notice. Then if you wish to respond, otherwise we condone the delay.
Not that on my side can be controlled.
The other side is not.
Yes.
Again, notice to so-and-so has been accepted by so-and-so. Let response affidavit, if so required on behalf of the respondents, be filed positively by the next date. Re-notify after 4 weeks.
Most of
31/7. Item 10.
Yes. 1, 4, 4.
Mr. Bora. Mr. Borua, why should we dismiss this application for non-prosecution? Nobody is appearing for Mr. Khatniar. We are not here to call upon all of you.
Names on.
Let us dismiss this application for non-appearance. Let him file another restoration.
Or else
Yeah.
you'll also.
No. Nobody appears on behalf of the applicant, the petitioner / applicant. The petition is dismissed for non-prosecution. Now let him come. We will restore it in no time. Let it suffer that. And 1484 days delay, that also they must consider.
Item 11.
Notice to
sole
sole respondents on steps being taken by the applicant within a period of applicant / Union of India applicants, Union of India, 3 others. Both 2 weeks, both modes returnable August.
10th August. Item 12 for admission.
Yes, kindly. There is the last order and the order.
Last order dated 20th of March.
That is also relevant, Lordship, and thereafter, and it was again listed on Lordship 15/5/2026.
Yes, Mr. Goswami.
Well,
what
my
you have to
approach-
say?
Well, yesterday night I have received the instruction. Only one day time. By day after tomorrow, I will file my appeal.
Now, you have to tell us 2 things. In the meantime, the bench has directed that till the time you arrange for the construction, then perhaps the same school be allowed to be continued.
Right.
And then you have to come out of the camp office. I mean, you have to take out that camp office. These are the directions. Though initially that was not one of the directions. Because all right, next week we are keeping as
Correct,
prayed
my
for by Mr. P.M. Goswami, that additional application. Let this matter come up for consideration on Tuesday, next Tuesday.
On 26/5, my lord, Honorable Supreme Court passed an order in respect of Tamil Nadu, wherein my lord it has been held all government facilities, including electricity, has to be discontinued from forest area. We'll definitely come with our alternative arrangement. Then we'll.
An affidavit. That's, there is an order, or we send you to the same bench. It's the bench procedure.
It's all right, my lord. We'll definitely make alternate arrangement, then we'll discontinue.
You have the document education department, so that it can be protected.
My lord, my lord.
Do we send it before the same bench to recall that order?
Not required, my lord.
Not required.
Not required because we have to look into their interest of the students.
No, that's okay. But then you have referred to the Supreme Court decision.
Yes.
Disconnect everything in the forest area.
Just for your lordship,
Keep it for now.
hey, John Kennedy.
If you think that the compliance of that order of Supreme Court, naturally, it has to be complied, then file an application for recall of this observation. This bench had not given you that observation.
Yes, ma'am, true.
This bench had directed for something else.
True, money. That can also be done.
Mr. Goswami, you have to handle it carefully.
My lord.
Question is that if at all there is an order passed by this court, if that runs counter to the directions by the Supreme Court, you have to abide by what the Supreme Court says, and simultaneously you have to seek a recall or modification of the order.
What I propose, my lord, let us merge this order, the order to be passed with the earlier. Instead of my lord recalling that, then the students will also suffer because Honorable Supreme Court has not said that to do it.
No, we will restore the order passed by us sometimes earlier.
My lord.
That make arrangement.
Exactly. The order says for just 2 lines, ma'am. A blanket moratorium shall be imposed on the extension of welfare schemes, public utilities, transport facility, electricity, all.
Correct.
So that blanket moratorium will not be imposed on the day. It will be imposed by the state within the time frame. So in the meantime, let us see if we can make alternate arrangement for them.
So we are not placing it next week. We are placing it after 3 weeks
My lord, my lord.
as bread forum. So see, have you followed what has happened?
Lordship, but
Now, this court had directed that the school the students be accommodated in a school where infrastructure should be developed. But the other bench said that no, you allow that school to be continued in the forest area. That cannot be done. So we are seeing, of course, the intention of the bench was to have the continuity of education of the students for that class. But then something has to be found out. Some way has to be found out. We'll see.
The other bench has pointed that so many students cannot be imparted education in such.
Correct.
That's
It can't be done in a forest area, no.
No.
It can't be done in a forest area.
And regarding that also directly.
There can be no justification. It's as important as education. So therefore, we have to find out some way out.
Yes, sir.
Yes, sir. Deeply available.
Up to 3 weeks.
A date may fix it.
24th June.
Of life.
Item 13.
This one, Lordship, my lord. This conductor, the AK person just now informed me through message that he was not keeping well, my lord. He's not supposed to. Which item 13, my lord.
Who is to argue this case? Mr. Purkais?
Yes, my lord, he just a message. That is why, my lord, I cannot mention my lord. It's just a message. So.
Anyway, they've given a statement. What is the response of the state in this?
Understanding of really is that also what speech was very brief.
What is your stand? Though of course, he's asking for time, but let us know what is your stand. Why should we keep these matters pending?
Lordship, some sort of
affidavit is required to be filed also. Exactly, Lordship. Because certain aspect of the matter, what has been mentioned in
The facts of the case.
yes, certain aspect of the, because I was there in the single bench also, Lordship. Certain aspect of the matter, we are supposed to give the response because all the points that has been raised in the appeal, we are not required to respond to all these points.
Have you done so?
Yes,
We had given you on that occasion of the last
exactly, Lordship.
state to respond. Have you filed your affidavit?
No, Lordship, we have received the instruction, Lordship. I am appealing for the response number 3 and 4.
You should take an adjournment, no?
Exactly, Lordship. I was intending, but since my friend has paid for some accommodation.
Let this matter, I'll jointly pray for let this matter consideration on your date in July.
Obliged, Lordship.
Item 14.
Yes,
In this case, Lordship, the respondent number 4, name has been shown in the Bible seal, is Lordship, as a honorary.
first demonstrate who you are appearing for respondent number 4.
No, Lordship, I am the.
No,
Lordship, I appear for 1, 2, 3, your Lordship, for the
No,
department.
Oh, all right, yes.
But in the final select list, his name appeared in the reserved category, Lordship. I am only sole candidate in the reserved category. If he is not appointed, Lordship,
Nobody come to the judgment,
Lordship.
come to the judgment impugned.
Lordship, in page number 220, terra number 10 is the relevant Lordship in this petition. Judgment, Lordship. Page 220.
Give us the paragraph of the judgment where it has been dealt with.
Lordship.
Give us the paragraph.
Paragraph 10 in page number 220 is the relevant Lordship.
Was permitted to appear in the general category or the comfort of the OBC bench. Could not have been made to approve. Legal record of the court such contentions cannot be appropriately in such meeting. How do you say that he had applied in the general category?
Lordship, kindly see page number 48C, Lordship.
Page 48.
Page 48, Lordship.
But why do we
His
get-
number, his roll
Just a
number,
minute, Mr. Hutt.
Lordship.
Why this is appointment pursuant to an advertisement of 2014
14, Lordship.
and respondent number 4 has been working for the last 10 years.
Lordship. I have
The
prepared,
disturbance of this.
Lordship, appellant prepared the writ petition in the year 2015, Lordship. Right, Lordship. Matter was pending before this honorable court, Lordship.
And that also post of PN.
Beyond,
Let us see, how do you say that he is a general category person?
Lordship, kindly see page number 48, Lordship, in my.
48.
48C, Lordship.
Hmm.
48C, this is the vernacular copy of the notice, Lordship.
48?
48C, Lordship. There is a 3 pages type copy is there, Lordship. Vernacular copy is 48C, Lordship.
Okay, is referring to roll number.
There is a table, Lordship. There is a roll number, Peon, Lordship, second table. Peon, in general category, there is a general also mentioned, where 020, roll number 027, 029, 038. 038 is the respondent number 4, which belongs to general category I have mentioned, Lordship. In the next page, Lordship, kindly see
038.
038, Lordship. This is the respondent number 4. Kindly see page number 49, Lordship. 49, Lordship, where the notice selection was made, Lordship, for appointment. In the PM category, Lordship, notice OBC, MOBC 038. They have mentioned the rule number 038 is a OBC
That's
category.
all right, but
They have, Lordship, respondent.
is that the only ground on which you say that he was a person of general category? He should not have been accommodated in the reserved category.
Due to his accommodation, Lordship, I am deprived, Lordship.
No. Why you say that he is not OBC? Only on the basis of this result or any material that is not OBC applied as general, something like that.
In this regard, Lordship, I have on various occasions approached at the time of filing of the writ petition, approached the authority. They have not furnished accordingly. I have
So
also
they have
filed
not
RTC application.
It still lies in the realm of,
They have not
conjectures.
provided any document, Lordship. Only they have filed
Why should we ask them to provide after so many years?
in the year 2023, respondent authority filed the affidavit in opposition in this case, Lordship. Thereafter, Lordship,
What
got
is the stand of
some
the-
document I
stand
have.
of the candidate in his affidavit before learned single judge.
Lordship, they have also, private respondent also filed the affidavit, Lordship. In the year 2023, I got this document, Lordship. Before that, I have no document, Lordship.
Respondent before that.
In my writ petition,
So some corrigendum also was issued.
corrigendum, Lordship. This corrigendum I, Lordship, received after filing the affidavit in opposition in the year 2023 by the department, Lordship. This corrigendum, Lordship, kindly see page 2112, Lordship. There also they have mentioned page 112, Lordship. Page 112, Lordship. In peon category, they have, Lordship, some correction was done in this, where in the both category 038 mentioned, Lordship. In general category as well as OBC and OBC category. Both category in the corrigendum also they have, my contention is that this corrigendum was not published in any newspaper, Lordship. This is my categorical statement in the affidavit in opposition. In the year 2023, they have produced this corrigendum before this honorable court. I have filed RTI application. They have refused to reply this document, Lordship. If at the time, it's in my categorically statement, Lordship, in the petition, Lordship. My statement is there.
Now tell us,
I have filed RTI.
Mr. Bordoloi,
Lordship,
can you hear us?
Yes,
Tell
Your
us whether respondent number 4 was, he had appeared as an OBC candidate or a general candidate.
as per my instruction, he is the OBC category, and in fact, I have in my affidavit in opposition, I have filed the OBC certificate issued in the name of the respondent number 4, Your Lordship.
Under what category he has applied, Lordship? That
Yeah. Take it. We have heard Mr. A.B.T. Huck, learned advocate for the appellant, and Mr. G. Bordoloi, learned standing counsel cooperative department. By this appeal, the judgment and order dated 10/2/2026, passed by a learned single judge of this court in WPC number 381 of 2015 has been challenged. An advertisement was issued way back in the year 2014 for appointment of 9 peons. 2 posts were reserved for OBC/MOBC, whereas 7 posts were kept unreserved, out of which 3 were allocated to women candidates. The appellant claims to have applied as an eligible OBC candidate who underwent written screening test, but his name was not found in the list of successful candidates. It has further been submitted that to his great surprise, he found respondent number 4 as a selected candidate under OBC category, even though he had applied for that post under the general category. This contention was raised by the appellant before the learned single judge on the basis of a declaration of the department regarding roll numbers of various candidates under various categories. And the roll number of respondent number 4 was found mentioned in the general category. Stop. The main contention of the appellant before the learned single judge, therefore, was that a person of general category could not have been accommodated in the category meant for OBC/MOBC. Stop. It appears that the contentions were countered before the learned single judge by the state respondents, as also respondent number 4, that he was an OBC candidate and that any misrepresentation in the declaration of the state was further modified, though of course belatedly. There is no cavil over the fact that the respondent number 4 is an OBC candidate, and there was no material before the learned single judge to conclude otherwise that the appellant had performed better than respondent number 4. Merely because the roll number of respondent number 4 was shown in the general category list, it could not have been conclusively held that respondent number 4 was not from OBC category. The learned counsel for the respondents number 1, 2, and 3 has also submitted that the caste certificate of respondent number 4 was scrutinized, and considering the merit of respondent number 4, he was accommodated on one post reserved for OBC/MOBC. So even otherwise, we are in agreement with the opinion of the learned single judge that the recruitment process was initiated in 2014, and respondent number 4 has been working on that post of peon for the last 11 years, requiring no interference at this stage. We find no merit in this appeal. The appeal is dismissed.
Obliged.
Item 15.
May I please the lordship? My lord, I am required, my lord, I prayed for a filing an affidavit, my lord.
What is it?
My lord, I prayed for a filing an affidavit, additional affidavit, my lord, to bring a notification, recent circular, my lord. In this type of disputes, my lord, they resort to that circular, my lord. That is not a part of the record, my lord. So, my lord, just a week's time.
But why do we let you do that?
No, my lord, if my lord, under that circular, my lord, if such overweight issues come up, my lord.
Overweight is all right, but did you question that no machine was used, machine was bad? You have not done that.
No, my lord, the machine.
For videograph, I mean, when pen drive was produced before the learned single judge, that every process was conducted. 12 kgs overweight is something which can't be overlooked. And now the process is over. And if at all you pass the initial test, there was a detailed medical examination within the scheme.
My lord, that's why, my lord, under the medical examination, this
say, then what is the use of putting a cutoff or putting a threshold that well you can't be more than 60 kgs or something according to your BMI?
No, my lord, that I will not claim any benefit that which is not supported by law, my lord. That is admitted. Now, only my respectful submission before my lord is that, my lord, if under the circular, my lord, if this type of disputes are there, my lord, this is
circular came when?
My lord,
no,
my lord, circular came.
Let us have a copy of the circular now,
my lord, that,
for us to permit you to file it later.
My lord, actually, I am today handicapped with my colleague. He has not returned yet.
सीधा वही कही है ना. Today, your level of preparation is not such that you address the court. All right, we'll grant you time. But then we grant you time sometimes in September. You file a detailed affidavit. Unnecessary. This is
no, my lord, my lord, I also
with the new gown that you wear, don't take up these matters. These are
my lord, actually these are the matters, my lord, before my honor, my lord. That's the problem.
That's all right, but then now your argument should be different.
My lord, I can understand.
As prayed for by Mr. A.R. Bhuyan, learned senior advocate, let this matter come up for consideration on sometimes in August 1st.
Obliged.
8 August, 5/8. Item 17.
May I please your lordship? Lordship, in this case, lordship, the appellant has preferred this appeal. Lordship, assailing the judgment and order that was passed by the learned single judge, lordship, in the judgment, your lordship will find page number 103. In the said judgment, lordship.
नहीं आप हमें बताइए 11 years have passed by.
Lordship.
We have 11 years have passed by.
Definitely, lordship.
Now we have given a judgment, whatever be the situation, we can't direct.
Lordship.
हमारा judgment है. Where is that judgment?
Lordship, so far the Debabrata Tiwari
have you gone through that judgment delivered by this court?
Yes, lordship. But so far the Debabrata Tiwari case is concerned. Lordship.
No, not Debabrata Tiwari. After that, of course,
no.
Lordship,
Yes, lordship, I admitted. Only my humble submission before this honorable court is that my case has been considered in the previous round of litigation. That was considered after the Debabrata Tiwari judgment was passed.
Would that make any difference?
And the learned single judge, while decided the case of the present appellant, lordship,
even if
not,
you, just a minute, even if he would have taken it into consideration, decided that. But now with the passage of 11 years, for whose ever fault, now can we direct for compassionate approach?
Lordship, after the judgment passed by the Honorable Supreme Court in the case of Debabrata Tiwari, now Honorable Supreme Court has, Lordship, in the case of Canara Bank versus Ajit Kumar GK, the Honorable Supreme Court has said that, Lordship, delay on the part of the no fault, if there is no fault on the part of the petitioner or the appellant, in that case, the delay cannot be count for the default of the administration, Lordship. That is the ground, Lordship.
But they shows that judgment.
Yes, your Lordship.
It's absolutely different from what we have been following. Does it take note of Debabrata Tiwari?
Lordship, Debabrata Tiwari judgment was not referred in this case, and it was decided completely in a different way. And so far the
let us see.
Yes, your Lordship.
Citation, please. Citation. Ms. Sharma, please look into that judgment. Debabrata Tiwari's judgment, our judgment pursuant to Debabrata Tiwari, where we have explained that in no circumstance can the delay be overlooked. In no circumstance the delay can be overlooked. I will. আর এইমাত্র যেটা দিলে এটা কি
citation to court. Supreme Court 2025 ARSC 123.
ARS. Copy আছে না স্যার? Extra copy.
তিনটা কপি আছে that people do not comfort.
Government of copy this one, it's a pillar. Government of copy this one, it's a pillar. Put this here lies on a file. Judgment copy to the user is because the admission agu করেছে গভর্নমেন্ট তো পঠাবো পড়া না নাই দিয়া কে ফাইল না ফাইল তো পিছত once you are bound to give us copies ও গমনা পাবো আপনার কেস করিলে না প্রসিডিউর প্ল্যান করে তো last month you might have been 5% ceiling. Now, how to break that 5% ceiling? That is the only reason. Whose fault? It's not the state's fault.
Lordship, there is an office memorandum, Lordship, as per the office memorandum.
2009.
Lordship, the Honorable Supreme
No,
Court,
no,
Lordship,
2009.
Lordship, the Honorable Supreme Court in the case of Lordship,
Sharma respond to the petition. Now, we are not inclined presently. Absolutely not. But you know, he has been able to tell us, show 2 lines from the judgment passed by the Supreme Court recently, that it says that if his hand to mouth and not only they fall in the standard of life, but if his hand to mouth, then these things can be ignored. But here the fault, we will not put it on you. Prima facie, it appears that initially the district level committee approved his name, but state level committee rejected it on the grounds that there was no post vacant within the 5% ceiling quota. He came before the High Court. High Court directed the SLC to again look into the matter. Again, the SLC looked into the matter and dismissed it. This time again, the quota thing was the reason. And thereafter, the single judge dismissed it on ground of delays. No difficulty. We are in agreement with what the single judge did, but we cannot ignore his argument also. In that case, we'll find, because he is also the applicant, the appellant also is the son of a peer who died in harness. So hand to mouth condition would be there. But where is the circular which says that if it is not within the, if there is no vacancy within the ceiling limit, the candidature of the person shall be carried over to the next year, wait for another vacancy for him to be accommodated. Is there a circular like that?
Well, I'll obtain instructions on that.
Lordship,
I'm told there is one. I'm told by the learned additional.
for a
advocate
moment,
there
your
is one.
Lordship may kindly come to the page number 32.
You respond to this petition.
I will.
We are even otherwise, see, look at this. Our views are very clear. Now, this way, we would be upsetting the entire card. And we have not done it up till now. So many petitions have been dismissed on this ground. We are not going to do it. But let's see, we have to review our decision. Because delay is something which weighs very heavily with us.
Just a minute.
Correct. You may be under a difficult situation, but 11 years you have been able to tide through, of course, with difficulty. Let us not get into that. Poverty should not be made a ground for rejecting a case or something. We will. Let us see what Ms. Sharma has to say, and let us see what is the consistent policy of the state in such matters. If there is no post vacant within the ceiling limit, what is done by the state? Let's see. Because can we falter the state on this count? We can't. Unless they are selectively applying the circular. Anyway, take note. We have heard Mr. What is your name?
D. Sharma, Lordship. My name has not been reflected in the cost list, Lordship.
We have heard Mr. D. Sharma. learned advocate for the appellant, and Ms. S. Sharma for the respondents. The appellant, who is the son of a grade 4 employee who died in harness sometimes in the year 2014, is agreed by the decision of the learned single judge in rejecting his claim for compassionate appointment merely on the ground of 11 years delay. In taking a decision for his being accommodated on any class 4 post. Immediately after the death of his father, the appellant had applied for compassionate appointment. The district level committee, Barpeta, had recommended his case for appointment on 25/2/2016 against a single vacant post. In the year 2015, relying on various circulars of the government and some of the judgments of this court. The recommendation of the district level committee was forwarded to the state level committee, which rejected such resolution of the district level committee in the year 2020, primarily on the ground of lack of vacancies under the compassionate appointment code. The appellant questioned such decision before this court by WPC number 1853 of 2020, wherein a direction was issued by this court to the SLC to reconsider the case of the appellant afresh based on the district level committee's recommendation, and also by applying the office memorandum dated 2/3/2009 within a period of 45 days. Next, pursuant to such a direction, the state level committee again considered the case of the appellant, but rejected it in the year 2023, reiterating the stand that there was no post vacant within the 5% ceiling limit for compassionate appointments in class 3 and class 4. Which decision was as per the OM dated 2/3/2009. The appellant, without losing heart, the appellant again approached this court by WPC number 1162 of 2024, questioning the second rejection by the state level committee. But by that time, 11 years had passed by, and the learned single judge did not entertain the petition in this instance. The contention of the appellant is that no doubt passage of time is an important factor, but if the fault is not on part of the applicant, the principle of law evolved with respect to compassionate appointment should not be applied in a straight jacket formula. He has further submitted that in accordance with the circular, if there are no posts vacant within the ceiling limit meant for compassionate appointments, some arrangement is made for considering the case of such persons in the subsequent vacancy within the limit. Ms. S. Sharma learned counsel for response number 1 to 3 shall respond to the aforenoted argument. And if possible, would bring on record the relevant circulars on which the appellant has based his arguments. So, the affidavit shall be filed on or before the next date. Re-notify August. We have our doubts, but then let us see with the new judgment that he has quoted, which he has cited.
12 August.
Highly obliged. उसको भी रख लो। हमारे पास
Item 18.
Legal lordship.
Yes.
Lordship, I am appearing on behalf of Amazon.
But that's all right. We are seeing you. You are appearing. Argue your case.
Lordship, we need a short time to file our D100.
What is the affidavit filed on behalf of the state or on behalf of the parties?
Lordship,
What rejoinder? Rejoinder for what fact?
Lordship, I am aware for this.
You should always speak the truth. Huh? Don't be, you have been asked to take time. We can't ask a lawyer who has not read the brief to appear and address. And we are not going to dismiss the case otherwise. As prayed for on behalf of the prisoner. When do you want it?
Lordship, when? After 2 weeks.
Who is your senior?
Amazon.
He should have told you few facts, no? As prayed for on behalf of the petitioner and agreed to by the council for the respondents, the matter is adjourned to your date after 3 weeks. Nothing we can do.
3rd August.
Bless.
Item 19.
I seek only 2 days accommodation, my lord. This case also I received instruction yesterday night, my lord.
We are not asking you to give them land or patta.
Yes, ma'am.
They are only she is also not asking us. They are only asking that make some arrangement.
Yes, sir.
Midway, you have thrown them out. Vagaries of
yes,
nature.
yes.
Just make that well.
By day after tomorrow, I'll file.
And not necessary at the place where Ms. Ghosh wants to live.
No, we don't want, we just want place. In
They are
some
living
place
under
to-
tarpaulin.
Yeah,
True.
and
If they are not landless, they don't deserve. They must go back to their respective states.
True.
we are from Assam. I have annexed
No,
also.
I'm only saying.
So they are from my lord, the
These
district
are
called
the
Botana.
caveats.
They have migrated to their forest, my lord.
Ms. Ghosh, these are the caveats which they have.
Yeah, yes,
Otherwise they are a welfare state.
Yes,
There is a land
It
policy
is
also. they can
endless.
apply
The
to-
difficulty is
for
this, it's endless.
yes, Lord.
You occupy some place in the forest land and then you come out.
We
and
don't
say
want
that
to stay
you-
inside the forest also, Lordship. We need a place to stay. That's my humble submission, Lordship. We are on the river bank.
There
Now
are
rain is.
so many landless people, my lord. There is just land
That's
policy,
right, but
they can
we-
apply under that.
Can we say that so apathetically? We can't.
True.
It is very difficult for us to say that, well, there are so many people, what do we do? We can't.
But there are people residing over government land. There are people enclosed
No.
inside forest.
See, we are not
So whom to
blaming,
prioritize, my lord?
we are not blaming you for the eviction, not at all.
My lord.
But we are only making a request that you being a welfare state, do something. We can't even ask you in black and white.
True, my
But
lord.
this
State
is-
has to be human, my lord.
It has to be
True, my lord. I have received all instructions. I
as
think they
prayed
will
for by
help them also.
as prayed for by Mr. P. M. Goswami, Learned Senior, Learned Additional Advocate General. The matter is adjourned to next week.
Deeply.
10 June. 10/6. Item 22-24.
Might be your lordships.
Yes.
My lord, your lordship has earlier given us time to get the matter settled.
No.
And the
We didn't ask you to get the matter settled. These are not issues where there could be any, collaborative decision. You said that talks are underway. Therefore, we grant.
yes, it is. And my lord, the appellant side also will agree that they are also in touch with the officers in the office of the deputy commissioner. My lord, I am only praying that some more time is required because There are 50 families, my lord, all are not coming
right,
together.
all right.
My lord.
The talks are still underway. Stop. For the the talks of settlement are still underway. For the aforementioned reason, Mr. Mazumdar, learned additional advocate general, seeks some time to inform this court about the outcome. Re-notify, give in August. All the matters.
12 August.
Deeply obliged.
I will come back after 5 minutes.
Item 25.
Yes.
Milord has on 27/8/25. An order has been passed, Milord. 27/8.
So who appears for the bank who is prosecuting?
My lord,
I'm sure. On behalf of Restaurant.
What? What do you want?
Lordship, we need a short time to file our reply affidavit.
At least orally inform us. No, this is a very peculiar situation.
my lord, Lordship has on 1st of April, that order has been passed directing them to file their affidavit.
No, that's all right.
My
They will
lord.
file an affidavit, but you must orally inform. Now, where does he go?
Due to some medical issue, he is not being appeared.
Anyway, well, we'll have to give some time. He is not briefed by a senior in any matter. As prayed for on behalf of the respondent bank, the matter is adjourned to. When?
After 2 weeks.
You don't have any apprehension of the property being attached? You've purchased it after obtaining no objection.
Yes, on the basis of the NOC, my lord. But there, the Lordship will pass and stay order because Lordship has passed.
That we don't do. We will quash that order, we'll do everything. But if there is no apprehension, don't press us to do that.
My lord. Obliged.
2nd June.
Second.
Item 26.
Yes.
My lord, the service upon the respondent has been completed. We have also made paper publications and we have also filed an affidavit to that.
Application not through the registry.
This is the double HRA.
My lord.
You are entitled for it. But then you are in, you are for the Navodaya.
For now.
Then you're right.
He was actually posted.
Yeah, follow.
No, ma'am.
Your decision is correct. The tribunal perhaps did not understand. They took a whole holistic view of the matter and decided.
Right.
Now, if the person would have been, if his family would have been there at his earlier place of posting, then he gets double H.
My lord. My lord.
If he chooses to take his family to somewhere, home
He kept his family in the home district in Sonepat. He was supposed to keep him in the last.
Awaiting the appearance of respond number.
So
Awaiting the appearance of sole respondent. The matter is adjourned to. But don't pass any order pursuant to the Act. If they file a contempt petition, they must accept and come here. We can't pass any stay order. If next time, if they don't come, if you give us the evidence that it has been received by him, then we can pass an order of stay.
And all the places they will register it through the notice many of them. But even the refer the publications are not located to the registry.
Why did you not go through the registry?
That was
How did you not do it?
My lord, that was a lecture on our part. I apologize for the same.
The present petition is directed against an order dated 20th of December 2024, passed by the Central Administrative Tribunal, Gauhati bench, in OA number 204 of 2020. By the impugned judgment, the tribunal has directed the petitioner / Navodaya Vidyalaya Samiti and 3 others, the petitioners, to pay double HRA to the respondent, notwithstanding the fact that the family of the respondent had not been residing in the erstwhile station where he was posted, but they were residing in his home state in Haryana. Navodaya Vidyalaya Samiti, next paragraph. Navodaya Vidyalaya Samiti operates residential schools across India, primarily for rural students, and provides free accommodation to staff on campus. As an autonomous body, it follows Government of India regulations and also relies on its own circulars for the benefits of the employees, including incentives for postings in hard stations like Northeast region and Union territories like Andaman and Nicobar Islands. Double HRA is one such incentive, allowing employees transferred to these areas to claim HRA for both, namely the new posting if living in private accommodation, and the old / last duty station if the family stays there in rented or owned housing. Next, it appears that the respondent was appointed sometimes in the year 2010 in Uttarakhand and was transferred to a Navodaya Vidyalaya in Car Nicobar, a union territory and a hard station. He shifted his family, instead of shifting his family to Car Nicobar or keeping them in his last posting in Uttarakhand, he kept them at Sonipat, Haryana, his hometown, his home district. He claimed double HRA based on various circulars, based on a circular of the Navodaya Vidyalaya Samiti, which provides that the employees posted to Northeast regions or union territories from outside can get HRA for the old station if they don't shift their families and keep them in rented / own housing there, along with HRA for the new station, if applicable. It appears from the records that the claim of the respondent was rejected multiple times because the application would, because entitlement would arise only if the family of the respondent were residing at the last or old place of posting and not at any place within his hometown, or else the respondent would not otherwise qualify for double HRA. Such a provision has been made to address hardships from transfer to remote areas. The tribunal directed for grant of double HRA to the respondent. Without appreciating the fact that the family of respondent had not been residing in the place where he was last posted. This court had directed for issuance of notice to the respondent by regular mode and had also permitted substituted service by publication in the newspaper. The petitioner of his own published such notice in the newspaper, which publication was not routed through the court, Considering this aspect of the matter, we direct the petitioner to file to deposit requisites in the registry within a period of 1 week, whereafter he would be given a form of notice, which shall be published in three newspapers in English, Assamese, and Bengali language, having good circulation in the area where the respondent resides, and shall submit the clipping of such notices published in the newspapers in the registry within a period of 3 weeks thereafter. The rule is made returnable in August or September.
9 September. Item 27.
Yes.
The matter is listed today for consideration of interim pair. Consideration of interim pair.
Consideration of
Interim pair.
interim prayer.
Well,
Yes.
it's a
No,
matter pertains to
it's our
special
interim.
family pension.
Huh?
Special family pension.
Huh.
In similar facts and circumstances, you also in another matter was pleased to interfere with the impugning order.
Where is that order?
No. The Ladakh Tribunal has failed to appreciate that medical expert medical ignored the view of the expert body. Supreme Court in lot of cases
Tell us the
says
facts of this case.
well, here the petitioner
The employee died of cirrhosis of liver.
multi-organ failure.
You explain to us.
Yes.
How do you claim special family pension?
Yes, Lordship.
Cirrhosis of liver is not because of any army. There was drunkenness, alcoholism.
Yeah, that has to be proved, Lordship.
The order is required to be stayed. You file your response. The stays are said.
Otherwise,
The impugn order passed by the tribunal shall remain. Otherwise, also you don't have a case, Mr. Thavildar. Therefore, we are normally we don't stay. इसके basis के साथ.
I'll explain that.
Supplementary list item 28 to 30. for hearing.
Yes.
May I please, your lordship? My lord, my senior counsel, Mr. H.R.A. Chaudhary is also there, but
How can there be a senior counsel? I mean, leading another senior.
my lord. I am not leading my senior counsel, my lord, he is by.
Mr. Chaudhary is here.
My
All
lord.
right.
Earlier
Yes.
occasion, my lord.
Yes.
My lord, this is a matter, my lord, wherein,
Who will address us, Mr. Chaudhary?
my lord, I have been.
My lord, I allow him, I authorize him to address
All
you
right.
also.
Yes, yes.
I'm online, my lord, please.
All
My
right.
Not be difficult.
My lord, the issue is, my lordship is already once heard the matter.
No,
my
no,
lord,
we have
regard-
forgotten. You tell
My
us.
lord, this is that's for.
Lordship is taking up this matter for hearing.
Yes.
Otherwise, this case is fixed on 7th of August, along with 2 other matters. And this case was they have made a mention, that's why this case is, suddenly it is before this.
If he's ready, we will hear it.
No, Lordship, we are not ready, Lordship. It is a surprise to us. And number 2, Lordship, in the meantime, UCC has also come into force. Not into
Correct,
force, it
correct,
has been
correct,
passed.
correct. It has been saved. It has been
Because
tabled.
if that is notified, then this will become redundant. So let us wait for 2 months, Lordship.
Then, my lord, the alternate forum for the registration of the Muslim marriages, my lord, is now, we are now, my lord, the people in the state. My lord, 1.2 crore population is suffering
Mr.
without the forum, my lord.
That is an argument which is misconceived. You know, a Special Marriage Act makes a provision.
No, my lord, the Special Marriage Act, we cannot go, my lord.
Why?
Because if we surrender to the Special Marriage Act, my lord, then the religious issue will come into play, my lord. My lord, we have, my lordship is well aware, my lord, that the conditions of the Special Marriage Act and the, my lord, issues under the Muslim personal laws are quite different, my lord. So that's why, my lord, if we surrender to the,
Just a
my
this, I mean, repeal of 1935 Act
my lord,
and this 2024 Act enactment.
my lord.
This is not taking away any rights. This is not interfering with your religious practices.
Absolute interference, my lord. My lord, we will make an attempt, my lord.
Then in the
Now,
meantime,
otherwise, Lordship, what I am trying to emphasize is that by making a mention, a matter cannot be preponed. They have to file a early hearing petition.
No, we
Otherwise,
have preponed it, my lord. We have
otherwise,
not
case
preponed
is fixed on 7/8/2026 along with, this is the order passed in
another
PIL for
case.
another case.
That is
All
an
these cases are
independent.
fixed on a particular date. Otherwise, if they want to do, I am ready on Thursday or maybe
No,
tomorrow also.
No, my lord, can it fixed on Thursday, my lord, because my lord. No, it will be a amount on sir. Then my lord, this PIL is delegate file position.
if we remember correctly, Mr. Puyan, on the last occasion, Mr. Chaudhary was talking about Qazis only.
Yes, madam.
He was not talking about all these, 1935, the earlier 1937 Central Act, then 1935, whichever.
Now, my lord, with all respect, my lord, to my respected senior friend is already there, my lord. He has already presented preliminary, my lord, submission on behalf of the all Assam Muslim marriages. My lord.
What the London Advocate General says is makes sense to us, no? Because there is a bill which is coming.
My lord, Uniform Civil Code, I have gone through, this act has not been repealed.
It has been repealed. I have a
My
copy of this.
But the
Yes, Lordship.
repealing provision.
Yes, in miscellaneous, I may read it, Lordship. The Assam Compulsory Registration of Muslim Marriage and Divorce Act 2024 is hereby repealed.
There are two acts. One is the Repeal Act and the other is.
They have challenged the Fresh Act.
2024 Act, my lord.
That is repealed.
That is repealed in the assembly. It has been passed. So we have to get a notification for that. From
This matter, then we can't tell.
Then, my lord,
then this whole matter will become redundant.
August.
My lord, may I pray, my lord, during this intervening period, my lord, some forum under the 2024 Act or under the 1935 Act, at least for the purpose of registration of marriages and divorces.
2 months, no? Wait for 2 months, we'll have
My lord,
everything.
many people are, my lord, suffering due to the, my lord, non-certificate. They even cannot apply for the passport also.
What is the way out, Mr. Advocate General, for this in the meanwhile? Registration?
They can register. before the sub-registrar's office.
Rule is not there, my lord. They are not.
No, there is rule 4 or
My lord.
some. There is
I'll examine it, Lordship, and if Lordship is pleased to take up the matter.
Mr. Sekia, as regards rule, there is another PL who recently filed.
Yes,
Says
yes,
that
my
rule
lord,
is
this
not
is-
met,
this
so
is the-
let there be a rule. That I think rule is not there.
Because ultimately everything will taken care of by the UCC.
No, but in the meantime, if somebody gets married, it is registered.
Let the idea Kazi, my lord. Idea Kazi may do it also, my lord.
Okay. In that case, Lordship, on 3rd, there is a meeting that just now I have received the instruction for finalization of the draft rules. Day after tomorrow, we are finalizing it.
Draft rules of this 24 exercise.
They are doing it. Now let it come in August. We'll hear you.
Lordship.
Let this matter come up.
For UCC also, we'll need the rules.
Yes. Let
My
this
lord, may I submit only one thing, my lord?
Yes.
My one case about August, if my land advocate general agrees, my lord, can it be preponed, my lord? Because registration is very difficult, my lord. People are suffering a lot, my lord.
No, for that, the adjournment is not for the purposes of delaying this rule. They are doing it, draft rule they have received. Whether they bring UCC or they don't bring UCC, they have to make a rule for this registration.
Yes, my lord. Not yet been done, my lord.
That is what Learned Advocate General is informing this court, that the draft bill has already come. So they just have to finalize it. So in any case, we are fixing it.
My subject to Learned Advocate General, my lord, if he is not inconvenient, can it be done in July, my lord?
No,
last prior to the vacation.
After 28th of July, let it come, Lordship. So I have no difficulty.
Proceedings, all matters are there on 7th of August. 7th of August.
7th of August.
7th of August.
All connected matters.
Let this petition be listed along with so and so on 7th of August. The date already fixed.
Highly obliged, Lord. Obliged.
Your Lordship, I beg to apologize for item number 10, Your Lordship.
What did we do in item number 10?
So, I have for delay, Your Lordship. Actually,
If nobody is there, what do we do?
And cutting Your Lordship, we reasons of personal difficulty, Your Lordship.
So we are strike that off. Strike that off. Let this matter come up tomorrow. Tomorrow you can seek time, whatever. But you can't leave it unattended, no?
No many standing councils.
You can't leave it unattended. Usko 10 का कोई order नहीं करना, तो list tomorrow. Yes, do you have to say something, Mr. Adil Ahmed?
Absolutely not, my lords. Your lordship is seized of the matter. The only difficulty that I would have liked to point out is that with regard to registration, if the state is keen on bringing rules, it will only further the cause of not only the constitution, but also the cause of a valid Muslim marriage, my lord. That's about it. That's about it. Because the entire basis of a Muslim nikah.
Mr. Adil Ahmed, very, very logical. That's what the state is required to do. The state is contemplating, and in fact, the draft bill also has come. Therefore, we have adjourned the matter. There's no use. They're not making a parallel proceeding unnecessarily.
Precisely. Deeply obliged.